$5,000 bond, Your Honor. We would ask the court to consider either reducing that to an OR or potentially cutting that in half. Again, obviously she's indigent here, so her financial means must be very limited at this time, Your Honor.
Ms. Collins?
And Your Honor, based on the number of offenses that the defendant is charged with, $5,000 is not egregious. Entirely based on the number of offenses, the type of offenses that she is involved in, we would ask the court to see $5,000 bond placed.
All right, find a note that according to my court, court network report, defendant has previous felony conviction and served previous prison term in possession of cocaine. Also was convicted of 2006 8 counts of forgery. And given the number of these charges and the significance of that, the court feels that $5,000 is extremely reasonable, so the court will do that the same. All right, we'll proceed on the pre-trial instruction for your current being shot up to the thing. All right, Thomas Barney Jr. Are you Thomas Barney Jr.?
This year.
Right, it's a case number 22-CR-159, State of Ohio versus Thomas Barney Jr. Hearing is available to be hearing to be conducted by Zoom. Mr. Barney's attorney is Jacob Wagner, attorney for this office. Currently, half the state is assistant prosecutor Collins. Defendant was arraigned last week. Was indicted with two co-defendants. Looks like he was charged with counts 1 and 2 and 11 through 14. Those include second-degree felony, 3 second-degree felonies, and 2 third-degree felonies, and a misdemeanor first degree. Bond set amount of $20,000. Mr. Wagner.
Your Honor, I can probably definitively say here that $20,000 is unattainable with my client, Your Honor. We're just asking for a set bond in an amount that would be reasonable that my client could potentially even maintain or reach.
Small.
Your Honor, again, we have the number of offenses and the level of these offenses, all the trafficking, security, or prison. Would also note that the defendant has a substantial prior criminal history, including multiple failure to appear.
All right. The court reviewed the Ohio Court Network report on Mr. Barney, and I note that what the prosecutor indicated is correct, that there are at least a half dozen, if not more, entries of failure to appear, including at least one conviction in 2005 and a misdemeanor. And these are mandatory prison offenses, so based on that, the court will leave bail. Your attorney will be in touch with you, Mr. Barney. We'll see if you can do that. All right, Amber Coyle is next, and Ms. Witt, I believe.
Difficult guy in domestic, a difficult person.
Are you Amber Coyle?
Yes, sir.
Case number 22-0153, State of Ohio versus Amber Nicole Coyle. Coyle is occurring by Jim from jail. He's a bail review hearing. Central Rule 46, her attorney is Daniel Witt, occurring in her office. Occurring in half the state is Prosecutor Collins. The defendant is guided with 3 co-defendants. 16 count indictments. She looks like she's indicted in counts 1 and 2 and 5 and 6. There's 1 4th-degree felony and 3 5th-degree felonies there. She was arraigned last week. The absence counsel bond said $2,500 and the court set bond at review today. Mr. or Ms. Wood, on behalf of the defendant.
Yes, Your Honor, we would ask the court for reduction to an NOR bond for Ms. Boyle. And just doing a quick search, it appears that she had does have 1 prior felony, and just from what I saw, it looks like that she was in supervision. We ask the court for reduction. I think she also has a nice community.
This follows.
Ms. Boyle has 1 prior felony in Idaho County in 2019, but she got 2 years in prison. But she has a substantial prior criminal history from California. It has not been in Idaho County for very long. She does not have a lot of ties to the community. Having an income here in the last, probably the last 7 years. Based on that, we would ask the court to leave the bond in place.
$2,500, given that the defendant does have ties to California, does have a previous criminal record, served previous prison term, court will leave bail place. Return to be in touch with you. We'll see you at the pre-trial before.
Thank you.
Mr. Wagner, do you have somebody else? I thought we were done with you.
My good friend, Mr. Robert Trout, pawned his off of me, Your Honor.
Oh, okay. Well, we're about fair play, I guess, huh? All
I
right.
think he's on the bench in Greenfield.
All right. Case number 22, CR 150, State of Ohio versus Robert Bolthouse. You are Robert A. Bolthouse.
That's right.
Hang on, I don't have him on here. Here we go.
Not on record there, I'm sorry. Now we are.
No, where?
All right, case number 22, CR 150, State of Ohio versus Robert A. Bolthouse. You are Robert A. Bolthouse, appearing from the jail.
That's right, Your Honor.
All right, this is a bond bail review hearing. Mr. Bolthouse was indicted on July 5th along with 3 co-defendants in a 16-count indictment. His attorney is Danielle Witt, appearing from her office and appearing from the prosecutor's office is Prosecutor Collins. The defendant is indicted actually in counts 9 through 14 with aggravated trafficking of fentanyl in the vicinity of school zone, 3rd-degree felony, aggravated trafficking of fentanyl, 4th-degree felony, and 2 5th-degree felonies, as well as a gun specification and committing drug abuse. The defendant was arraigned last week. Bond was set down at $10,000. He was heard on the bond.
Yes, Your Honor. Obviously, I haven't had a chance to speak with Mr. Bolthouse regarding these charges, but we do ask the court for reduction in bond. I don't believe that he has ties to the community, and as I said, I haven't seen the facts of the certain case or anything, but would ask the court for reduction.
Ms. Collins?
And Your Honor, we would ask the bond to remain the same. It's not egregious based on the nature because of the fact that while he does not require a penalty conviction, a review of his CCA shows that he currently has a misdemeanor warrant pending from Brown County for failure to appear on the V1 traffic violation, but obviously he has a tendency to not appear for court. So based on that, we would ask the court to then bond as it's currently set.
All right. The court notes that the Ohio Court Network shows the same warrant as Collins mentioned. And given the presence of gun specification, which is mandatory prison term, and the nature of these offenses, the court will leave by bail in place. Your attorney will be in touch with you, Mr. Bolthouse, and we'll see you at your return. Thank you. All right, Christina Gill's next up. She's still in municipal court, deputy.
They walked out.
Can't hear me. Ms. Gill and Ms. Gill is supposed to in municipal court, so we may have to skip her.
I think that's where there is.
Okay, deputy, is Ms. Gill still in municipal court?
No, she's back here.
All right, she's next then, please.
Okay.
Thank you. All right, this case number 22 CR 101, State of Ohio versus Christina D. Gill. You are Christina D. Gill, appearing there from jail.
Yes.
All right, Ms. Gill's attorney is Dennis Kirk, appearing by his office, appearing from the prosecutor's office as Prosecutor Collins. Defendant was arraigned last week, called him co-defendant. She is charged in counts 1 through 6 with aggravated trafficking and methamphetamine. 3 counts, one of those is a second-degree felony without mandatory time, and 3 counts of aggravated possession of methamphetamine. One of those is a second-degree felony with mandatory time. The others are third-degree felonies. Bond was set in the absence of counsel, and the court appointed Mr. Kirk, and so pursuant to Rule 460, court is refusing bail this time. It's Mr. Kirk, anything you'd like to say?
Thank you, Your Honor. I did represent Ms. Steele back in 2019 on a charge that she's placed on community control. Looks like she successfully completed that. Showed up for all her court appearances then. Not aware of any failure to appear. She does have ties to the community, has a residence out on US 50 near Lynchburg. And I was presented with some information this morning from her family that she has surgery scheduled for the 14th this week at the Indian Regional Medical Center. She also has a MRI scheduled today, approximately at 1:30 at Adams District Hospital. She's got a blood clot and is dealing with some cancer and some other issues that require these surgeries. I've got any documentation that needed, and my hands was dropped off of me. So based on the fact she has a ties to the community, she did report in the past to all of the reporting areas and medical conditions. I understand there's a mandatory time here, but I think allowing her to address these medical issues will assist in progressing the rest of the case. So would ask the court to consider reduction in bond or an apartment.
Collins?
What's her current bond, Judge?
20,000.
As the state would know, her current administration would the fact that if she's off probation for Highland County, she's just been released for the 2019 act session and a felony. She also previous to that had probation out of Brown County. And I'm not sure about this residence 150. I know that in June, when her indictment was returned, we could locate her there. So she was just picked up recently. So, and again, multiple of her counts, or at least one of her counts, carries mandatory prison. So we would ask for her to move on the case.
Your Honor,
Where is your actual residence, Ms. Gill?
I'm actually been resident where I get out of surgery, I lose 1.5 taking care of stuff.
What is that residence again?
But after I get out of surgery,
I asked you what your residence is going to be.
my residence is 2835 this 50, and I turned myself in.
All right, that's all I need to know. All right. And when is the surgery that's scheduled?
I've got a double mastectomy scheduled, I've got nerves repair scheduled,
All right. The court then is going to order that they'll be reduced to LOR on the conditions set forth in the original rate entry, and that you receive the scheduled medical treatment that had been stated here. If you simply use that as an excuse to get out of jail and did not get it, then the court will revoke the bond or be taken back in custody. You provide proof that you're getting your medical treatment to the probation department. As soon as you get out of jail this morning, well, are you released out of municipal court?
Yes, sir.
All right. As soon as you get out of jail this morning, you report, and then you get your treatment, and you comply with all the other orders. All right? Thanks. All right. Tiffany Green.
I don't have Tiffany Green on here. What's her case number?
22-057.
Okay, I'm gonna add her in here.
All right, are you Tiffany Green there in jail?
I'm still not on here.
22-CR-157, State of Ohio versus Tiffany Green.
I'm still not on. She's not listed in here, so I'm trying to find her. I'm adding her in.
22-CR-157.
Yeah.
Green with me on here.
I'm just gonna have to add her. Add to schedule. Add to schedule. Now where is she? Okay.
All right, we're on record now. Case number 22-CR-157, State of Ohio versus Tiffany Green. You are Tiffany Green, occurring from the jail.
Yes.
All right, the defendant was arraigned last week on a 22-count indictment where she's indicted with 2 co-defendants. She's indicted in cases for counts 3 through 8 and 15 through 22, including several second-degree felonies carrying mandatory time, third-degree felonies, and fourth-degree felonies. Bond was set in the absence of counsel. Her attorney is Dennis Kirk. He's attorney from his office, attorney from the prosecutor's office is and Collins, the prosecuting attorney. Bond was originally set at $1,000 matter set for today. Kirk. Yeah, he's covering. Oh, wait a minute. What?
Mr. Wagner's covering Mr. Armstrong.
Oh, I'm sorry. I'm looking at the wrong sheet there. I left Ms. Gill's sheet out. So it is Mr. Armstrong. All right. So Mr. Wagner's covering for him. All right. I'm sorry. Thank you for pointing that out, Mr. Armstrong or Mr. Wagner.
I spoke to Mr. Armstrong, and he asked me about it. I said I would. Obviously, coming all request, Your Honor, any reduction would be appreciated. I'll give Mr. Armstrong here in a few hours, let him know where we're at. Obviously, file a motion if he sees necessary.
All right, Ms. Collins.
Thank you, Your Honor. The state will first note the serious nature of these offenses, most of which bring mandatory prison time. While Ms. Green does not have a prior substantial criminal history, only one prior account that I can find on our CCH, these are very serious crimes that do carry mandatory prison. Additionally, during a search of the residence upon the arrest of Ms. Green, it's likely that additional charges will be forthcoming based on what's found in the home.
All right.
Your Honor, I would also note I anticipate that there's going to be mention of an adult disabled daughter that is going to take care of. The state has taken action with DE to ensure that she is taken care of.
All right. Well, I do know that there is a prior felony conviction. See, there's a couple of hemp warrants. I'm not sure what that is for. Usually indicate case in the next criminal case. But given the nature of these charges, a significant number of them, the seriousness of them, and representation states that likely additional charges will be filed before the court, but bail remains the same. Your attorney will be in touch with you this reading, and we will see you as your pre-trial. Michael Barber is next. Case number 220154, David Ohio versus Michael Barber. You are Michael Barber, appearing there in the jail. All right, Mr. Barber was arraigned last week. The absence of counsel, attorney is Mr. William Armstrong, who is not available this morning. Mr. Wagner is David Wagner preparing for him for this hearing, and Prosecutor Collins for the state. Hearing to be conducted by Zoom. The defendant was indicted on the 5th of July and was arraigned last week along with 3 co-defendants. Total 16 count indicted. Mr. Barber is indicted in count 7A, aggravated trafficking and possession of methamphetamine for 3 felonies. Bond was set about $25. Matter set for review. Mr. Wagner. Yeah,
again, Your Honor, as this we're coming here from Commissioner Armstrong, obviously, as Commissioner Armstrong asked for any reduction for being that proper. But I will update Commissioner Armstrong here about an hour before the bond is set at and advise him to file any motions you feel.
Collins.
Your Honor, Mr. Barber does have a prior felony conviction, albeit a 1994 conviction, I believe. So based on that, we would ask the bonder to please.
Mr. Barber, your residence is Golden Bloom Lane.
Yeah.
You live there alone?
Yeah.
All right. How do you get around? Do you drive?
Yeah.
All right. I'm going to reduce your bond to an OR only on the same conditions I previously ordered last week, which would be your report to probation department under pretrial supervision. They'll be able to make their arrangements to pay your service fee. And then 30 days, you report to probation department as soon as you get out of jail this morning. You know that's at 117 Main Street, across the flagway?
Yes.
All right, as soon as you get out, you report to them, and then you'll be required to comply with those conditions. You stay in touch with your attorney, Mr. Armstrong. He's unavailable this morning, and I'll reach out to you, make sure you stay in contact with him. All right, anything, okay, so I believe you have a pre-trial scheduled for August the 3rd, I believe, for pre-trial at 1 o'clock. Right, thank you. All right, I think the next one is Christopher Pence. Mr. Kirk, you're covering for Ms. Barber.
Yes, that's correct.
Mr. Pence sent us a note wanting to contact the prosecutor about no information. I guess he doesn't understand it. No, the document is there. Christopher Pence, please.
We're back.
May I address the court, Your Honor?
Yes.
Is Bill done?
I think so, yes.
Alright.
Yep. All right, thank you.
Great job.
You did a wonderful job. You got one of those guys out. Yeah.
I did.
You set the bar high. All right. All right, are you Christopher Pence?
Yes, sir.
All right, yeah, this is case number 220152, State of Ohio versus Christopher Pence. Mr. Pence is appearing by Zoom from the jail. His attorney is Sarah Barber, who was not available this morning. Mr. Kirk is going in for her. By Zoom, representing the state is Prosecutor Collins. The defendant was indicted, along with 3 co-defendants, a total of 16 counts in the entire indictment. He's indicted in counts 1 through 4, which are aggravated possession of fentanyl-related compound, aggravated possession of that, packaging drugs and possession. Kurt? Mr. Pence, this is a bail review hearing, so you have the attorney, and I want to go ahead and address this matter, and then once you've had a chance to talk with counsel, then we will move forward. All right, Mr. Kirk?
Thank you, Your Honor. I'm not very familiar with the case other than a brief update Ms. Barber gave me, which was the type of charges. I'm not sure what the current bond is, but yes, ask the court to consider a reduction in bond. This is not made most one. Looks like he is local and has some ties to the community, so we'll just ask the court to review that. And then Ms. Barber sees that she can file additional motions.
All right, Ms. Collins?
I would agree with Mr. Kirk that Mr. Pence's local has ties to the community as well as the court system. I've known Mr. Pence through the court system since 2010. He has a substantial criminal history, having been extreme failure to community control, things of that nature. We would ask the court to leave the bond in place to ensure that he doesn't appear before and, frankly, doesn't ever fix it. Now, sense.
All right, the court's looking here, and I see the previous convictions, and he has served a previous prison term, so based on that, for $25 is a fairly insubstantial bond, so I'm going to insubstantial bond, so I'll move that remain in place. We have a pre-trial set for the 3rd of August. We're trying to be in touch with you, Mr. Pence, and get her information to reach out to her jail to discuss what she might want to do. I did receive your note that facts up to me, but bill of information is when there's no indictment pending, there's already an indictment pending, so it's too late for that. We'll just wait and see what happens there. So talk to your attorney, and she can help facilitate whatever disposition might occur in this case. All right, thank you. All right, Deputy, we're going to arrange this for Walker. We'll go ahead and do that by Zoom since we already have you there. Yes, sir.
Oh, jeez.
All right. We're good to go, Mr. Collins. We got Mr. Walker, 2017 non-sport case for arraignment. Stephen J. Walker. You don't have to stick around.
What's his case number, Judge?
17 CR 120. Steve with PH.
Your Honor, he refused to fill out his visiting request.
All right, thank you. All right, case number 17 CR 124. State of Ohio versus Stephen James Walker. You are Stephen James Walker.
Yes, I am.
All right, Mr. Walker, you were indicted back on July 11, 2017, actually 5 years ago to the day, on a charge of non-support, a 5th-degree felony. And it alleges that beginning on or about January 1 of 2003 through December 31 of 2016, you did recklessly abandon or fail to provide support established by court order to a CH born 9/11/2001 as ordered. Hey, be quiet. As ordered by Conning County Juvenile Court. Case number is there and prior administrative order. And the failure during that period of time to pay support included a period of 26 weeks out of 104 weeks. And that is a 5th-degree felony. It carries a possible prison term of conviction of between 6 and 12 months and a fine of $2,500. Now, I have not received your attorney form. You'll need to sign that for me to appoint an attorney for you. Pardon me?
I gotta pay for a home rate here. Over 8.
Well, I don't know anything about that. You'll have to get that and provide that. Would you be quiet? Quit interrupting me. I'll hold you in contempt. Yeah, well, just be quiet. I don't care whether you're sorry or not, just be quiet. Now, I was talking. What I said is, one attorney represents you in this matter. I need to have you sign that form. Now, are you working? All right, how much money are you making? All right, you need to put that down, and where are you living? Okay. All right, so, you own any property? All right. All right, well, you need, again, here's the way this works. When I ask you a question, you answer, and then you stop. You don't start speaking and speak over me. I'm not interested in hearing your life story. This is not the time or place for it. This is simply a arraignment. Now, you need to sign that form, and as soon as you sign that form, I'll find that you're indigent. I'll appoint an attorney for you, but it's not going to be effective until you sign that form. So you need to put your information on that form. The deputy said you refused to do it. So you're going to need to put your information on there, your address, your date of birth, who's living with you. Okay. And then you have to sign it. And the information on there about what your self-employment is. But if you're only making $100 a day, that's not a lot of money at this point. That doesn't make you qualified. So the court will appoint an attorney for you, Dennis Kirkfield from Ohio. Enter a not guilty plea on your behalf. We'll set a bail review hearing. If you do not make the bail set by the court, will be set for July the 13th at 9 a.m. by Zoom. If you're still in custody, if you're main bond, then it won't take place. Your first pre-trial will be set for July the 20th at 1 p.m. on Zoom. Unless you make bond, in which case you'll appear here in person. Your final pre-trial will be August the 17th at 1 p.m. And your trial date will be September 19th at 8 a.m. Now, this is a 5-year-old case, and 40-hour records that you were summoned to appear at 2 different occasions did appear. And so the court will set bail at the amount of $2,500 cash surety or property, plus your own recognizance. Your own recognizance is your promise to appear, and if you fail to appear, you could be prosecuted for an additional felony and convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a service fee deposit of $171 before you're released. If you make bond, you are to report to the probation department at 117 East Main Street in Hillsborough, Ohio. That's across the flagway station uptown. Report there immediately upon release. After that, you report to them once a week for 4 weeks, and after that, as they may determine, Go random drug testing, provide phone numbers for home cell employer. If recommended by probation, you evaluate for substance abuse, mental health, treatment of any treatments indicated, enroll in, follow that, or dependency of this action. You'll also be under house arrest if you're a residence there, and did you say you live in Middletown?
Yeah, well, staff here.
Didn't I just tell you to quit talking, just answer my questions? Now, you're not taking direction very well. One more interruption. All right, I'm holding you in contempt. You are hereby sentenced to 10 days in jail, which will not count against any sentence if you are convicted. Now, if you make another word before I'm done here, it's going to cost you another 10 days. Be quiet. I'm tired of you interrupting. Stop! I said stop. Be quiet. Keep your mouth shut. You have a constitutional right to remain silent. You better use it because it's costing you every time you open your mouth. I'm tired of your interruptions. Now, quiet. Quiet means quiet. I don't want to hear another word out of you. I don't want to hear a sound. If you have to sneeze, put your hand over your mouth. I don't want to hear another sound. Now, you'll be under house arrest at your residence in Middletown, which means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, an appointment with an attorney or a probation officer in this or any other case. May also attend any kind of schooling or job training, education programming. You also may attend church. All right, now, do you have any questions? Now you may speak. And I want to hear, if you have a question, ask a question. I don't want to hear any speeches. Just ask any questions you may have. Yes, well, no, not now, because you got 10 days to do. So you couldn't keep your mouth shut. That's your fault. I warned you many, many times. Then after that, you have to post a bond of $2,500, although we will review that Wednesday morning. But you know, it's been 5 years since you were indicted, and we haven't known where you're at, so I'm not real comfortable with letting somebody like that go on a no-R bond, which is why I'm going to require a bond. Now, do you have any other questions?
No, I'm sorry, or if I can take care of this money, with money, I can go get money from my sister on it, and then tell me
Well, and you better get her a call. But right now, the answer to your question is no, you're going to do your 10 days. I held you in contempt after at least a half a dozen times I told you to be quiet and you didn't listen. So, you're going to have to learn to listen to a judge, and at least to this judge. I don't care if you listen to anybody else. When I'm talking, you listen to me. So, you good? Now, I told you repeatedly to be quiet, and I told you to get talking. All right, so